Nice, nice T-shirt.
It's on the shirt I had, so.
That's it?
Yes, sir.
You want, well, I'll give you one.
I don't have no clothes. Can you?
Okay. Well, what's the problem? You know, why are you living just with one T-shirt?
Because I was staying in Baton Rouge, because I didn't have nowhere to stay out here. And I went to jail in Louisiana, and they
For what?
extradited me out here
For sir what? For what?
for my charge.
What, you have a charge in Baton Rouge?
No, it was for here.
The theft of firearm?
Yes, sir.
Okay, so they picked you up in Baton Rouge.
Yes, sir.
You didn't have anything here, sir.
All right.
Since like April.
And you've got one T-shirt?
Yes, sir.
That's it?
And I got my work uniform.
Okay,
I'm
well,
working every day, so I'm
okay.
out of jersey.
okay. You ought to go, like Salvation Army or some of the other places where they have nice clothing that is slightly used.
Yes, sir.
And you don't have to walk around with a T-shirt, you know,
Yes, sir.
but you want to kind of dress nicely, certainly in here.
Yes, sir.
But Goodwill and, you know, there's some other place I think has some pretty good clothing. Anyway, that's how you can get a little bit of a wardrobe until you get on your feet financially.
Yes, sir.
Okay, you're charged with this theft of a firearm, and this is a state jail felony, which carries with it up to 2 years in the state jail, Langston. All right. We got a problem, so.
You know, I've spoken to my client a little more about this ankle monitor issue, and I think we have. See, like, kind of what happened.
We got a problem. I mean, they state that it was deactivated 4 months ago. And where is your monitor?
It's on my leg, sir.
But it's dead, right?
Yes, sir. It is.
It's charged, Your Honor. I think she's charged, it's charged, right? Or is it-
I've been trying.
No, he deactivated, so it
Well,
doesn't matter. It's,
back in
you can get charged, you can use it as jewelry but it just doesn't do any purpose. It doesn't serve
I
any
think, Your Honor,
purpose.
she
otherwise.
has, I'll let you know kind of what happened in that time period.
Yeah,
Jordan,
Can she speak, Your Honor? Explain what happened?
yeah,
I've already talked to
this
her.
is your time because I'm about to make some orders that are gonna affect your freedom. Go ahead.
4 months ago, I was pregnant. I ended up being in a relationship with somebody. I didn't know them that well. Probably through childhood. And whenever time I did that, I was getting away from something. I went there. It wasn't the best situation. I ended up getting pregnant during that time. That person beat me. He tried to sell me, like sex traffic me. I was fighting. He beat me with.
How is
everything.
it somebody else's fault that you didn't pay for your ankle monitor?
was
How is
being-
that somebody else's fault, man?
I was being held captive at the time, like, and I
For
basically
4
had,
months you've been held captive?
I didn't.
This has been deactivated for 4 months. Nobody does that.
I literally had to scream outside the house for help in Dallas, Texas. You can look his name up. He's actually like.
Well, did you file on him for kidnapping?
Yes, sir.
What happened in the case?
Bruises. He's personally in jail right now because of this.
All right.
I have bruises. there.
Once again, but for 4 months, you haven't had a device that you were supposed to have. And that's your problem. You're charged with deadly conduct here. And there was a good reason that we made sure that we wanted to know where you were and this happened where?
The incident or with this?
Yes, the incident, no, that you said that this person,
Dallas.
I went to Houston with him. and
what are
he
you
took me
doing in
all the way-
Dallas?
He took me all the way to Dallas and he took all my.
What are you
phones,
doing in
everything.
Houston?
That's what I was trying to explain.
See, that's why we have these devices, so we know where you are at all times.
Yes, sir. And during that time, like basically, he took all access to everything. I basically had to stand outside the house and.
You made a choice of who to pile up with.
You're right. And
That's your
I
problem.
left that situation. And so I was getting back. And I just never had a chance to pay. But I can pay today. And not only that, like, I don't have no issue. Like, my only thing is.
You've got a big issue.
I don't, like, I didn't do it.
You got a big issue on this order of the court.
I'm just trying to get past this. I can't go, like, I don't even know. Like, I don't know.
That's where you're headed. I mean, that's
And
where
not
you
only
go
that-
when you don't follow the orders of the court. For 4 months, my goodness. I didn't know about this.
And the only reason why you put it on me, just to make sure I wasn't late for court, like I didn't show up for court and I showed up for court. That was the only reason why you put it on me. I never been in trouble before. I ain't run.
It doesn't matter. The court
or
can,
anything.
for good cause, any good cause, order bond conditions.
Yes, sir. I
But
understand.
but what you've told me is you decide when the bond conditions and what bond conditions are gonna be followed. Not me, and I'm supposed to be the one setting it. But for 4 months, you have been violating a condition of bond, and then we kind of stumble upon it because we have so many cases, we can't be watching everybody. We have to trust that they're gonna follow the rules. And
And
sometimes it happens where you, a day or two, and there's no harm done, but we're talking about 4 months.
And I still found.
And then you're getting involved in issues, criminal issues in other
No, I
counties.
didn't get involved in criminal issues.
You were
That's the
part
thing.
of something
No.
that was, you
I
said,
didn't do anything.
you wanna just continue to just interrupt me through this whole thing? It sounds like you're the kind of person though that kind of bullies your way into your way. You want it on your terms and when you don't have it on your terms, then you interrupt and you make excuses, but the bar is set for everybody and they have to get over the bar. And you hadn't been over the bar in 4 months. And that was something that you had an obligation to tell me as much as the bondsman did. But you haven't been following a condition of bond for 4 months, my goodness. That's serious. Very serious. And what we normally do in the cases like this is your bond is revoked. You're in jail and we'll sit this out until we can dispose of this case. That's what happens in all the cases. Sorry, but you had a chance, I have to be able to trust you and I don't. This is a big gap of a problem.
I think, Your Honor, the argument she's trying to make.
We're talking about a crime of violence that you've been charged with.
Didn't do it. It's no.
Well, you presumed innocent, but but the grand jury says there's probable cause to believe you did. Because of that, I have to rely on that as a probable situation. So that's why bond conditions are set. And that's all we're talking about.
Your Honor, I think the issue was because she got involved with someone who ended up being in a very violent, bad situation, who got taken kind
I'm
of.
talking about 4 months not telling me about.
Well-
That's what we're talking about.
Well, we don't, she just recently got free and that, so she was kind of held for him for a while. So that's,
No, when I can see that for 4 months, she's been held she's been kidnapped for 4 months, let me know. But I haven't read about that in the paper and that would make the news. Don't tell me that you hadn't in 4 months been, had time. And John, here's what we'll do is I'll give you a hearing on it and y'all can produce witnesses, but until then, she's, it defies logic that she has been held captive for 4 months. And I want to see some proof of that.
we'll get that. Your Honor.
All right, all right.
Okay. We can be in custody for now, so.
Your bond is revoked. Yes, because you hadn't had a monitoring on it. You hadn't called me about it and talked to us.
Possible.
And it was deactivated a long time ago. That's your responsibility. It's a condition of
I have no
bond
idea.
and you must have that or you're not released. You must have that, but I've already, you know, you're gonna interrupt me all day long. Is that what it is? Boy, that's rude.
No, sir.
I mean, if there was a crime for that, you'd be guilty of that one because you interrupt. Anyway, that's what I'm gonna do, John, is those findings and see what y'all, I don't know what y'all plan to do in the disposition, but you can have some time, talk to her before we send her,
Absolutely. That's what
away.
I'd like to do.
but I've got to have some conditions that you know, so we know that she's supervised and you're not being supervised by the court. And that's what you're supposed to be. And you were on your own supervision, which is not the way it works. All right, well, let me know. Thanks, John. We're here for business. Okay, who else? Did you have something?
Claudia Marks, she's outside. Her case was reset because we don't have a report from Griffon,
Okay,
but we don't know that she ever went to see Dr. Griffon because she's on.
what do you
bond.
want to do?
And it was suggested by the clerk that maybe the court would want to address that she must go take herself to Dr. Griffon.
Okay, bring her in.
Okay,
Okay. What case is that?
Claudia Marks.
What's her name?
Renisha Bassard.
Okay, yeah,
Yeah, we
We
have.
need her out.
We sent the paperwork.
all right.
I'm not sure if it's got an Ellie yet.
Not yet.
But it's.
I need that. Wherever it is.
We just signed her up.
What is her name again?
Renisha Bassard.
Please. Thank you. I think I brought it onto my desk. Maybe we'll see if I watch it over on my desk, but I don't have it up here. I have Rebel Arm, and then, yeah. Maybe it's on my desk. I might have.
Sorry.
Did you? No, I'll have it on one.
Yeah.
And. Thought that was reset this morning.
It was, but we wanted to. I think the real stuff.
Paragraph 1 is the difference.
Okay, and then, get it on.
And then the 7.
Yes.
Yep, I got it.
That's it, yeah.
I knew it started with.
Thank you very much. We call 22-39851, the state of Texas versus Renisha Bassard, who's present with her attorney, Mr. West, and the state's attorney. What do we, I don't have anything.
I'm trying to get it to you, Judge.
Okay.
Batteries are dead on every one of these tablets.
Oh, boy.
This is one.
I know, we're meeting with them tomorrow to go over battery stuff.
Well, people aren't plugging them into when they leave here.
Well, that's all.
22-398-51 is called. Does the defendant who's present with her attorney waive a formal reading of the indictment and the arraignment here? Can we proceed as such?
That's right.
In summary, this indictment alleges that on or about April 15th, 2022 in Jefferson County, Texas, you committed the third-degree felony of deadly conduct. Do you understand what you're charged with here?
Yes, sir.
Yes. If convicted, you face no less than 2 nor more than 10 years
Yes, sir.
confinement in prison, and a fine up to $10,000 can be assessed for any third-degree felony. Do you understand?
Yes.
An agreement has been reached in this case. Can you read that into the records?
Yes, your Honor, the agreement is a cap of 6 years.
6 years.
Yes, sir.
All right, so we're looking at no less than 2, no more than 6 years in
Right.
prison.
Or probation, deferred probation. I think she's open to all of them.
Deferred or unadjudicated probation up to 10 years. What about regular
I
probation?
think she sells for regular probation too. She doesn't have a.
You can't remember. This is kind of a weird one, isn't it?
Is deadly conduct with the,
On
with the
deadly,
The firearm, isn't it?
Yeah, I know, but didn't we?
If it
have
has a
that-
deadly weapon attached to it, can it be?
Uh,
It's 3G.
I don't remember. On this-
That is perfect, sure.
It says Article 42A53 does not apply to defendant when it is shown that a deadly weapon is defined as used or exhibited during the commission of felony offense or immediate after. And the defendant used or exhibited a deadly weapon. So that's on the law parties that wouldn't be.
Okay.
So 42A054, looking at subsection B.
Hold on, so. There was always there was something weird about this in the past. The statute, but. Okay, fine.
Under subsection B, it says it does not apply to a defendant when it's shown that a deadly weapon was used or exhibited during the commission of a felony offense or immediate flight therefrom. And then number 2 says, and the defendant used or exhibited the deadly weapon.
Mhm.
And so this is not allowed parties. This is, we're accusing her. Yes.
No, it's just weird that. It wasn't. I guess it didn't, it wasn't specifically.
Stated in there.
Enumerated
Right.
in the numerical sequence of crimes. Didn't we have?
Because there's,
We dealt with this issue one time and we had a bunch of disagreement over it, but it clearly says any offense involving where the use of a deadly weapon, I mean, it wouldn't make sense. It wouldn't apply. I mean, I don't, the elements of deadly conduct certainly seem to be
All right, in there.
no less serious than
Because in the guidance.
a deadly weapon
No, we discharge a firearm.
was used or exhibited.
I guess there are ways on deadly conduct that you could recklessly engage in conduct that places another in imminent danger or serious bodily injury without using a deadly weapon.
Right.
So it's only if there's allegation of a firearm and that they use and exhibited one, a deadly weapon.
I think there's other ways to get deadly conduct without getting a deadly weapon. Which doesn't make sense.
All right, so it looks like those are the only two options. Deferred or unadjudicated.
2-6.
An agreement has been reached. Again, where whatever sentence shall not exceed a cap of 6 years in prison. And is that your understanding of the agreement? If I follow this, you have no right of appeal of your case. Do you understand? How do you plead to this indictment charging you with the third-degree felony of deadly conduct, guilty or not guilty?
Not guilty. I mean, guilty.
You gotta pick one.
Not guilty. I mean, sorry, guilty.
What's your, think about it, relax. Okay, what is it you're gonna plead? You've pled not guilty twice.
I have to plead guilty, so there's no doubt.
Are you guilty or not guilty? That's the question. Okay, all right. Well, that's okay. Yeah, you can't force you into this. All
I'm
right.
guilty. I mean, guilty. Sorry.
No, this is,
Judge, I
I'm
don't,
guilty. I didn't understand the question. Sorry.
what did you want to say, Mr. Lane?
just since she's pled not guilty twice, I just wanted to make sure she had time to think about it, not just make a rash
Yeah, I
decision.
thought there was a decision made and we were over lunch.
Yes, sir.
and
Right.
Then
Just
came
in my
back.
words, sorry.
That's
Man.
fine.
Guilty.
All right, okay.
I'm positive. I'm so sure. Judge Stevens. Sorry about taking wrong.
So how do you plead then?
Guilty.
Is that your final answer?
Yes,
Are you pleading guilty voluntarily and because you are indeed guilty of what this alleges?
yes, sir.
I'm going to show you what's marked as State's Exhibit 1. And did you sign that
Yes, sir.
voluntarily?
Yes, sir.
Understand it, discuss it with your attorney. Are the contents all true and correct?
Yes, sir.
State's Exhibit 1 tendered into evidence.
No objection.
Without objection admitted. Among other things, this states you are mentally competent to enter your guilty plea, which is freely and voluntarily made. You know what you've been charged with. Indictment's been read to you. You've read it. And you've thought about it and you are guilty of this crime and any lesser included offenses. You are giving up your rights to a jury trial, the right to the appearance, confrontation, cross-examination of witnesses. You were totally satisfied with the representation by your lawyer. All true, so help you God.
Yes, sir.
State's Exhibit 1 is made a part of the record for all purposes. Is a pre-sentence report waived?
Yes, Your Honor, I think. We'll-
Okay, I want everybody to
Today, if that's-
sound in on this.
Yeah.
What? Okay.
Yes, Your Honor, I think she wants to move forward today and not do a PSI.
Okay, go ahead.
Your Honor, I would request in this case, my client give deferred probation. Some of the reasons why is that she has no criminal record. She had this, I think she has some pending misdemeanor charges that may be related to this or sometimes after that, but it's not. She has no convictions for that. So the fact that she has a clean record, this was a disagreement regarding her her child's father, however you want to describe him. She apparently had a dispute with him. A gun came involved. She had a gun for her protection. And then somewhere along the way, there was a shot fired. Luckily no one was hit with the shot. She has been cooperative, even though, like I said, this morning we had an issue regarding the ankle monitor. She was here to be on court on time here, didn't have any issues there. And I think I'm looking at here, the other misdemeanor is pending as a evading arrest or detention. I think when the cops got there, she did take off running from them. Or I'm not sure that the fact that I know she was charged with evading arrest and detention as part of this offense. Your Honor, this is the case where we were here this morning and her bond was revoked. She, at that point, said she wouldn't have to take the deal. We were kind of working on a deal with the
Well,
state.
it was revoked because of this
Ankle monitor, yes,
issue on
absolutely,
that
yes.
ankle monitor.
But
that-
prior to that, me and Mr. Laird started negotiating a deal on this. And we were gonna reset it for a little more time to negotiate a little further to try to get her. I was gonna request from the state probation. And I think that's why Mr. Laird did offer the cap, whereas they were not going to agree to probation, but they were giving her the ability to get probation from the court. And we just asked the court to give her probation and whatever conditions the court thinks are required to make her successful.
Okay. State.
It's problem I have with all that is the use of a deadly weapon. You know how this county is just turning into just one place after another where
Tombstone.
everybody's using a gun and nobody ever settles their fights with words or anything else. I'm trying to remember. I mean, there was a lot of things going on out there. It looked like there were a bunch of people, but witnesses all backed up to the complainant in this case that she also had her children in the truck and pointed it at a group of people. And I think she actually fired one shot at the group. When they got to her, she had 3 outstanding city warrants, of course.
How'd she miss the group? We can't hear what you're saying.
I never shot, I never had a gun. I asked them right there to test me for gunpowder residue. They didn't. And they had cameras and everything, and the police even said they didn't see nothing. The only people who said that I shot was his recent girlfriend and his childhood best friend. I was in the car. Everybody else can testify and said that I stayed right by our apartment. The incident happened right by the park. I never had a gun. I promise, Mother Great, I'm gonna pass away.
Well, then how did we get to,
Shot fired.
how did we get to this charge if you didn't have a gun?
You know,
Well, but you just pled guilty under oath saying you had a gun, that you threatened these people with fire.
You're in a catch-22. I mean, this is what the crime is that you just pleaded guilty to. And you knowingly discharged a firearm in the direction of a person. And that's one of the elements of this crime. That's a problem. You either admit it or you don't. And if you don't. So we're
If you
We're
didn't do it,
kind of
now it's time to
impasse.
fight.
I didn't do it. I didn't shoot again. I promise.
okay, well, we can't go forward with this. All right. All right, well, then, what we'll do is, well, the bond is revoked. And I told you what the bond is, and it's gonna be doubled and she'll be held in custody, but all we can do is put this up for trial as soon as possible and set it for trial. Whatever, everybody says,
I can disagree. I can disagree, just do the probation. I just don't want to go to jail. I really don't. I agree with it. I just don't want to go to jail. If I could just do probation, I accept all the penalties. That's it. But I can't, I just didn't shoot again. I asked them right there to text for gunpowder residue. It's everything, even the police, like the cameras, all of that.
I'll look at it, Judge. I promise I'll look at it really hard. I promise.
well, I mean, but of course, the only other thing is a no contest plea,
Please, no contest. Yeah, that's what I want to do. No contest.
but they gotta agree.
Yeah,
with
that's
it.
up to the state.
Now, here's the problem with that is,
They never do that.
if you're honestly saying you didn't do it, okay, that's what's gonna be, because nobody else told you this. If you mess up on your probation later, you can't come back and say, I didn't do it, you'll go to prison, okay? You could go to prison on the best of ways, you say that now, but there's a lot of things that can trip you up.
I'm gonna try my hardest.
So- If you did not do this, now's the time to say that, and I can look at it, I'll look at it again and talk to people, we'll see. I don't wanna take a no contest plea, because you really seem adamant about the fact you didn't do it.
But I also don't want to sit in jail. I think it's still a nation. I sit right here and take.
Right now, that you can't enter the plea. The state doesn't agree to them. So we have a bond issue that's gotta get dealt with, so.
Yeah, I already had him, I know somebody following him on,
I do not ask
notice
for
on
jail.
request for response. I'll file that soon, and we have him on here.
All right, but right now the bond is revoked and
Prepared yet.
for
Yeah.
failure to maintain the bond condition of having a GPS device as required. But I can bring her back. You know. Next week or
Every week.
whenever, when y'all, as soon as y'all can figure
I
something
think
out.
except for the week of July 4th, this past Monday, I'm not here. So
All right,
I
that is,
have,
that is all.
I am number 2 this coming Monday next door,
Okay.
but that'll be at 1 o'clock, so Monday morning.
Okay.
I'll say guilty. I just don't want to go to jail. Can I do that right now?
No, you can't do it now. You've already said enough. You kind of put yourself in a bad position. You can- All right, what's next?
Come on.
Should have learned. Before I go back there. Right.